Ready, start. The promise of good governance and constitutionalism cannot cast the rule of law and human rights as mere end products of a judicial process. It would be to the credit of the incumbent to institute, as soon as it comes to power, a legal framework and democratic polity in which the rule of law is widely accepted and effectively enforced as evidence to its future commitments. Justice is a critical aspect to ensure respect for human rights and the rule of law. It is necessary to prevent future violation. Justice deters similar acts in the future and promotes peace and human rights while consolidating the new regime as one bound by the rule of law and therefore distinct and different from the problematic past. The degree of justice depends on a variety of factors: historical, political, military, socio-economic, as well as others. It is shaped by the nature of the past, the obstacles of the present, and the future needs of the society. These trials are conducted by courts that convene once a week in every cell and sector. Since the system is entirely dependent on community participation for its legitimacy and success, attendance is a statutory duty of every Rwandan. Mandatory participation with absence leading to pecuniary sanction, however, takes away the voluntary nature preferred in informal process. Conversely, it may be the only effective way to enforce a congregation of a people polarized along ethnic lines in the aftermath of a genocide as a community and encourage such interaction as may augment forgiveness and reconciliation. While charged with the onerous task of dispensing criminal justice through public truth telling for crimes against humanity and genocide, the judges under the Gaka law draw a legitimacy from their process of appointment and consequent state sponsorship and the enforced participation of the community. This is simply a change in the mode of state domination as the overtly coercive agency of the court is replaced by the covert state ideological penetration through community mediation schemes with the states cooperating the sanctioning power of an ongoing social relationship. The GACA could very be the vehicle of state suppression of the majority opinion against its power and control. This informal state connotes active intervention to suppress or modify specific behavior within which the informal institutions neutralize conflict by responding to grievances in ways that inhibit the transformation into serious challenges to the domination of state and capital. The modification and suppression of racially determined behavior through a desirable outcome is nevertheless aimed at appeasing the Tutsis, the political constituency of the incumbent government clothed in the rhetoric of peace and reconciliation. Appeasement of the Tutsis forms the crux of the inherent power imbalance which must be considered when attempting to resolve crimes of deep-seated racial intolerance through formal processes. The Gaka law was negotiated and drafted by the Tutsi majority government and limits the mandate of the Gaka tribunal to crimes committed in 1994.